Welcome and thank you for joining part one of our 2025 Half an Hour for Healthcare webinar series on PAGA and wage hour audit basics. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. The presenters will do their best to get to everyone's questions. For CLE credit, a verification code and QR code will be displayed at the end of the presentation. Scan the QR code to access and submit the digital attendance form. This streamlined process ensures accurate and efficient CLE credit processing, so have your smartphones ready. Copies of the webinar recording and presentation materials, along with a link to our CLE form, will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Elizabeth to get us started.
Thank you. So we're going to start with an overview of the new PAGA statute and then discuss some specifics that employers can be doing to take advantage of that statute. So let's go to the next slide, please. And next slide. And next slide, please. Perfect. So the California legislature passed legislation amending the Private Attorneys General Act on June 27th, 2024. Those changes apply to PAGA actions in which notice was given to the Labor and Workforce Development Agency, or LWDA, on or after June 19th, 2024. And the revision has a number of pro-employer amendments. So it's helpful for employees to be familiar with the statute and how they can take advantage of it. Next slide, please. So under the revised statute, an employee must have suffered every violation he or she is attempting to bring on behalf of other aggrieved employees. That provision was in response to a decision that allowed plaintiffs to represent employees as to any labor code provision, even if they had not personally suffered a violation of those provisions, just as long as they'd suffered at least one labor code violation. So this reform helps limit the scope of PAGA claims. The revised statute also provides that the Superior Court may limit the evidence to be presented at trial or otherwise limit the scope of any claims filed to ensure that claims can be tried effectively. This amendment codifies the decision in Estrada and allows employers to make some arguments based on manageability. The revised statute also allows for plaintiffs to seek injunctive relief, which had previously been unavailable under PAGA. There were a number of changes to the penalty structure in PAGA. Before, penalties distinguished between initial and subsequent violations, with initial penalties generally being $100 and subsequent violations generally being $200. Now there's one penalty amount that can be awarded of $100 per employee per pay period, and a higher $200 penalty can be awarded per employee per pay period if within 5 years preceding the alleged violation, the agency or court issued a finding or determination to the employer that its policy or practice giving rise to the violation was unlawful, or if the court determines that the employer's conduct was malicious, fraudulent, or oppressive. There are also reduced penalties for isolated, non-recurring events that haven't extended beyond either 30 days or 4 consecutive pay periods, and in those situations, penalties are limited to $50 per employee per pay period. There are also reduced penalties for wage statement violations. Those penalties are generally $25 per employee per pay period. In the case of a violation of Section 226A8, which deals with providing the employer's legal name and address on wage statement, that penalty is $25 if the employee would not have been confused or misled by the correct identity of the employer. Derivative penalties have also been eliminated for Labor Code Section 203, which is failure to pay all wages at termination, and Section 204, which is timely payment of wages during employment, and Section 226, which is inaccurate wage statements. Employees cannot recover penalties for violations of those statutes in addition to penalties recovered for the underlying claim giving rise to the violations of those statutes. As long as the violation was neither willful or intentional for Sections 203 and 204, or neither knowing or intentional for Section 226, or failure to provide a wage statement. So in those cases, if it wasn't knowing intentional and didn't deal with a failure to provide a wage statement, then you don't recover the derivative penalty. The revised statute also makes clear that for employees who pay weekly rather than biweekly, penalties are reduced by 50%. That corrects what was an unfair penalization of employees who paid on a weekly basis and who were essentially subject to double penalties, as opposed to employees who paid biweekly. The revised statute also provides for a greater share of penalties to go to employees. The old version of PAGA provided for 25% of penalties to go to employees and 75% to the state. Under the new statute, 35% of penalties go to employees and 65% go to the state. The revised statute also has additional reductions for employers who attempt to be in compliance with the labor code. So if before receiving an LWDA notice or records request, the employee has taken all reasonable steps to be in compliance with all provisions identified in the LWDA letter, then penalties are capped at no more than 15% of the total available penalties. An employer takes all reasonable steps if it conducts periodic payroll audits and takes actions in response to those audits, if it disseminates lawful policies, trains supervisors on applicable labor code and wage order compliance, or takes appropriate corrective action with regard to its supervisors. Whether an employer's conduct was reasonable is evaluated by the totality of the circumstances. And after the LWDA notice is sent, penalties are capped at 30% if the employer takes all reasonable steps to prospectively be in compliance with all provisions identified in the notice within 60 days of receiving the LWDA notice. Next slide, please. There's also an expanded cure provision for many provisions, an employer can cure a violation by being in compliance with the underlying statute specified in the notice and making each employee whole. The employee is made whole when the employee has received an amount sufficient to recover any owed unpaid wages due under the underlying statute specified in the notice, going back 3 years from the date of the notice, as well as 7% interest, any liquidated damages required by the statute, and reasonable lodestar attorney's fees and costs to be determined by the court or agency. In cases where the amount of unpaid wages due is in dispute, the employer can cure the alleged violations by paying amounts sufficient to cover unpaid wages that the agency or court determined could reasonably be owed to the aggrieved employees based on the violations alleged in the notice. It's not clear how useful this provision will be to employers, given that substantial discovery would likely need to occur to evaluate the amount of potential damages that could be owed. And given that the provision provides for damages and attorney's fees, it may not always provide employers with a realistic way to cure a case early. But, time will tell on that. The new statute also provides for cures for issues involving wage statements. So for violations of Section 226A8, which, again, deals with the employer's legal name and address, the statute allows for a cure on a showing that the employer has provided written notice of the correct information to each aggrieved employee. The notice needs to identify the correct information for each pay period in which a violation occurred. For other wage statement violations, the statute provides for a cure on a showing that the employer has provided fully compliant wage statements to the employees, or reasonable digital access, if that's how employees usually get their wage statements. And those corrections need to be made going back 3 years from the date of the LWDA notice. Next slide, please. There are additional procedures in the revised statute for potential early resolution of PAGA claims. Employers who have at least 100 employees in the PAGA period can request an early evaluation conference and a stay of the proceedings before or simultaneously with its responsive pleading. The request must include a statement from the employer identifying which allegations it disputes and which it will cure, and then the court will set an early evaluation conference. The purpose of the conference includes evaluating whether any of the alleged violations occurred and whether the employer has cured them, the strengths and weaknesses of plaintiff's case and the employer's defenses, whether any part of the plaintiff's claims can be settled in whole or in part, and whether the parties should share any information to facilitate early evaluation and resolution of the case. If an employer makes a request for an early evaluation conference, the employer has to include a statement as to whether it intends to cure any or all of the alleged violations and identify the allegations it disputes. Once the request for an early evaluation conference and stay of the case is submitted, the court will then enter an order staying the proceedings and scheduling a mandatory early evaluation conference within 70 days. If the employer submitted a statement saying that it intended to cure any violations, the employer then needs to submit its proposed cure plan within 21 days of the court's order setting the conference. If the employer disputes any of the violations, the employer also has to submit a statement of basis and the evidence it has for disputing those violations. And within 21 days of the employer's submission of the cure plan, the plaintiff then submits a statement as to the factual basis for each of the alleged violations, the amount of penalties claimed for each violation, and the basis for calculating those penalties, the amount of attorney's fees and costs incurred up to that point, any demand for settling the case in its entirety, and the basis for accepting or not accepting the proposed cure plan. If the neutral evaluator accepts the employer's proposed plan for curing any alleged violations, the defendant then has to present evidence within 10 calendar days or longer if the parties agree to a different deadline, showing that it has cured those violations. If the neutral evaluator and the parties agree that the employer has cured the alleged violations, then the parties can submit a statement to the court setting out the terms of their agreement. And if nothing else remains in dispute at that point, the court will treat the submission as a proposed settlement. Otherwise, the case will proceed as to any disputed issues. If the early neutral evaluator or plaintiff does not agree that the employer has cured the alleged violations, the employer may file a motion to request that the court approve the cure and can submit evidence showing the corrections. All statements and evidence submitted in connection with this conference are treated as confidential settlement negotiations under Evidence Code 1152. The statute provides that the early evaluation process won't extend beyond 30 days unless the parties mutually agree to extend that time. The statute also provides that nothing prohibits the employer from independently curing violations, and nothing prohibits the parties from agreeing to their own mediation process. So this provision for an early neutral conference allows for the possibility of resolving PAGA cases early on in litigation before incurring substantial expenses. The process proceeds on a fairly expedited timeline, so it may be difficult for employers to take advantage of it, but nevertheless, it may still be a useful tool for employers to get plaintiffs to provide the basis for their allegations going forward and may be helpful in resolving cases early. There's a separate process for employers with fewer than 100 employees during the PAGA period. The statute allows those employers to submit a proposed cure plan to the LWDA within 33 days of receiving the plaintiff's PAGA letter. The LWDA then sets a conference within 14 days of receiving the employer's proposed cure plan, with the conference occurring no more than 30 days after that. At the conference, the LWDA is supposed to determine whether the proposed cure is sufficient and what other information may be necessary to evaluate the sufficiency of the cure, and the deadline for the employer to complete the cure. If the cure includes payment of unpaid wages, the LWDA is supposed to determine whether the employer should pay the proposed cure amount into escrow or provide some other form of security. If the LWDA finds that the cure is not sufficient, the employee can proceed with a civil action. If the employer is allowed to proceed with the proposed cure, the employer must complete that cure within 45 days of the conference and provide a sworn notification of the cure to the LWDA, along with a payroll audit and check register if the violation involved a payment obligation. The LWDA will then verify that the cure was completed, and if it believes that the alleged violations have been cured, it will notify the allegedly aggrieved employee, who can request a hearing within 30 days of that determination. If the LWDA then determines that the cure was adequate and the violations have been cured, the allegedly aggrieved employee will not be able to proceed with the civil action. And if the employee disagrees with that cure determination, the employee can appeal that determination to the Superior Court. And the statute provides that no cure or proposal to cure may be deemed as an admission of liability. There's a slightly different procedure if the cures for a violation of Section 226 related to wage statements. The employer can cure those alleged violations within 33 days of the postmarked LWDA letter. If the employee disputes that the alleged violation of Section 226 has been cured, the employee must provide written notice to the LWDA, including the specific grounds for disputing that the cure was accurate. And then at that point, the LWDA provides a written notice of its decision. And if the LWDA determines the violation was not cured, or if it fails to provide timely notice or any notice to the employer, then the employee can proceed with a civil PAGA action. And if the LWDA determines that the alleged violation has been cured and the employee disagrees, the employee can appeal that determination to the Superior Court. An employer can't use this notice and cure provision more than one time in a 12-month period for violations of the same provision. This cure gives employers with fewer than 100 employees the opportunity to potentially cure or to potentially avoid any litigation by using this procedure with the LWDA. But again, it is a fairly expedited process, and it may be difficult for employers to take advantage of it. So one important takeaway from these PAGA reforms is that employers should be regularly reviewing their policies and practices to ensure that they're in compliance with California wage and hour law and other employment laws, because doing so can help the employer take advantage of lower penalties in a PAGA action and puts the employer in a better position to potentially take advantage of these cure procedures or early conferences that could help shorten or avoid litigation. So regular audits should provide employers with an advantage going forward in PAGA litigation. And with that, I'll turn it over to Galen to discuss conducting audits.
There we go. Hello. All right, can we go to the next slide, please? So an audit is typically done preemptively, and there's many different ways that you can conduct a wage and hour audit, but there are a few things that are, comparable and are done in almost every wage and audit. So the first thing that you'll need to do is determine the scope of what you're looking at. Now, this can either be a category of employees. We're going to audit all of our nurses, all of the phlebotomists, all of the IT workers, right? Depends on exactly what is the area of concern. The second kind of scope that you can look at is specific issues. So for example, there was a recent change to the rounding laws, and you want to make sure that, for example, you're not rounding meal breaks anymore. You can look at that specific issue. The third category would be to narrow by a location, a department, or even a specific business unit. Say there was a new acquisition or a new branch was just opened, and you need to figure out whether there's any issues in that specific area. So once the scope of the audit has been determined, and one other thing on the scope as well, in general, a preemptive audit, you can really define what the scope is. But if you're in a situation where you've received a PAGA notice and you're following and want to take advantage of the cure provisions, that scope is generally defined by the complaint that you've received. Once you've defined what the scope is, you really want to start collecting all of the relevant information, which will, again, be dependent on what you're looking for, what the scope of the audit is. So the goal here is not to examine everything, but you want to look at a representative sample to figure out what is necessary in the situation. If you're doing a preemptive audit, then maybe 10, 20% is enough. This is simply to identify potential issues so you can figure out what would need to be fixed. If, however, you are in the PAGA cure provision process, you would need to analyze enough employees to satisfy the LWDA and potentially the court, if it's challenged that far, that you have actually cured all of the violations alleged in the complaint and the PAGA notice. So we recommend kind of when you talk with the LWA in the early conference, identifying and determining what a representative sample would be sufficient in that context. Beyond that, sometimes it's necessary to do a site visit for the audit where you actually go out and look at the work site itself. Not always necessary. That's very dependent on what the allegations are. Oftentimes you will need to identify the supervisors to figure out what the informal practices are. If you have, again, a PAGA cure provision, you might need to submit a declaration from those supervisors as opposed to simply having an internal discussion with them. There's a question about privilege. In general, having counsel conduct the audit is preferred, right? These are confidential communications, and you want to make sure that the privilege is maintained. If you're conducting a preemptive audit, there are some issues with having counsel conduct the audit because it's not for the purpose of litigation. But these are generally privileged communications when there's already an active litigation that's ongoing. Some other issues that often come up are kind of where the plaintiff is alleging that they were not provided with an adequate rest break, for example, what does the physical facility look like in terms of do they need to, or do they have enough time to kind of leave their workstation, scrub in, scrub out, wash their hands, do any sort of sanitary procedures that they need to do? Does that give them enough time to actually take their full meal or rest breaks, which is an issue that's come up a lot recently with the Huerta decision. And oftentimes, again, if you're trying to prove that those violations have been cured, it's helpful, to submit a declaration or maybe a statement. It kind of depends. We haven't really seen many of these play out yet. We hope a statement is enough, but sometimes you might need a little bit more. Once you've identified all of the issues, then you'll need to figure out what changes need to be made and figure out some way to prove that those changes have been made, especially in the context of the PAGA cure provisions. Can we go to the next slide, please? Sorry, can we go to the next slide, please? Thank you. And so here are some general goals for an audit. Most of these are focused towards the preemptive, the audit situation. However, all of these are also helpful when you have a lawsuit that's addressing these specific issues and you're in the PAGA cure provision process. One thing just to think about is what types of things are you going to want to agree to, and how are you going to certify to the LWDA that these are things that you have actually implemented within the time period that they're requiring. So for example, if what you've identified is a problem with the policy itself, updating your policy might take more time than the LWDA cure process allows, which is just, again, another reason why you might want to conduct regular preemptive audits to make sure that, for example, your policies are compliant and that you don't have any ongoing issues. Can we go to the next slide and then the one after it to look at wage statements? Here, as everyone is well aware, California is very specific about what types of information need to be included on wage statements. And I'm sure we all have a good sense of what the potential problems are. But some of the really easy low-hanging fruit things that we've seen a lot of recently are employers, especially healthcare employers, who don't include all of the applicable hourly rates in effect. This is very common when there's a non-discretionary bonus. So for example, a shift differential. And we've seen a lot of plaintiffs recently arguing that not including all of those applicable rates on the wage statements is a violation. So the cure, as Elizabeth mentioned earlier, is to simply submit a revised wage statement that does include all of the required information. So given the quick timeframes for the PAGA cure provision, we do recommend that you make sure your wage statement vendor, whoever you're using, has the capability of providing these revised wage statements. There should be a pretty easy process that will allow you to simply address whatever issues have been raised in the PAGA notice and then issue those to employees. It's pretty easy to prove that you've complied when it's a wage statement violation. You simply show that you actually have submitted the revised wage statements and that the issues addressed have been cured. Can we go to the next slide and then the one after it, which is alternative work schedules. Now, this is another area where we've seen an uptick in a lot of litigation, especially in healthcare companies. It's very, very popular for healthcare workers in particular to have an alternative work schedule. There are some very specific laws that govern what an alternative work schedule looks like. And those are very specific in the healthcare context as well. So the goal here, I mean, the liability here is obvious. If you have somebody who's not working your standard schedule and they don't have a compliant alternative work schedule agreement, in place, then there's very easy for a plaintiff's counsel to show that there were overtime violations and all of the associated penalties with that. So when you have one of these lawsuits, what you'll need to do is show the LWDA that the liability doesn't exist because there was a viable and effective alternative work schedule agreement. So here, the takeaway is to conduct an audit, whether it's a formal audit or not, just to make sure that you have all of the documentation that you're required to maintain in order to show the LWDA that the liability that is at issue is being addressed or has been addressed. So for example, you need to keep, let me pull up the notes, copies of all of the proposals for the alternative work schedules, all of the communications with the employees about the proposals, and all of the results from the elections. You should also keep all of the supporting information and documentation about the alternative work schedule. Now, holding on to all of that can be an issue given the amount of time, and there are some very specific requirements that are different in the healthcare context as well. So again, just conducting an audit of categories of employees who are in an alternative work schedule on a preemptive basis to make sure that you have all of that documentation can be very helpful, because if you're in the LWDA cure process, you'll need to submit all of that information on a very abbreviated time frame. And if you already have it ready, it makes it much easier on you down the road. That's about all I have. If we can give you guys a few minutes back from your day. We have a CLE code, which is SS3711. And just scan that QR code and you can go ahead and fill in the information there. And as always, please feel free to reach out to either Elizabeth or myself or any of our other experts on these issues if you have any further follow-up questions.